Welcome to San Joaquin Spotlight, a public affairs program featuring conversations about life in the central San Joaquin Valley. This program is brought to you in partnership between KFSR 90.7 FM and CMAC Fresno. I'm your host, Sevag Tateosian. Today, we're going to be talking to local attorney and also professor at San Joaquin College of Law, Larry Artenian. Welcome to the program.
Thank you, Sevag.
So how did you get involved in the legal profession?
Well, that's just one of those things where you get to the end of college and you have to decide what you're going to do with yourself. And I tried working, and that didn't sit so well. So I thought I better get back to school, and applied to law school. And one thing led to another, and that's how it happens.
So as you were growing up, did you ever think that you were going to be a lawyer? Or was this one of those maybe kind of things?
I think everybody else thought I was going to be a lawyer. I'm not really sure. I know that I thought about it from time to time, but it was not like the driving passion of my life or anything like that. It seemed like a good thing to do.
So you get to law school, you're going through classes, and what are you thinking?
Well, I'm thinking I have to figure out a way to how to get out of this. Well, as you know, I know you've got a law degree, and it's a lot of hard work, and it can be at times an intense experience, but sometimes it's fun too. So you kind of get caught up in the wave of completing the task and don't think too much about what else you're going to do other than try to cross the finish line.
Something that you look back at, are you glad you did it? Instead of doing something else?
Yeah, I'm glad I did it. I wish sometimes that there could be 2 or 3 of me so I could go off and do all of these other things at the same time. It's a pretty demanding task to get through law school, and you pretty much do it to the exclusion of other things while you're doing it.
And for the record, you actually taught me at the law school contract law, so I just wanted to put that out there. How did you get involved into teaching then? Because studying law and teaching it seems to be 2 different things.
Yeah, I guess that's probably true, but as a lot of trial lawyers will readily acknowledge, that you have to have a certain amount of ham in you to get up in front of a jury or get up in front of a courtroom and talk. And I'd been involved in competitive public speaking in high school and had always been comfortable just talking to people about things. And so, speaking to a jury is not a lot different sometimes than speaking to a group of people in law school, trying to explain things step by step, beginning from square one. So I always had kind of an interest in that sort of thing, and when the opportunity arose, it seemed like a pretty natural thing to do.
Public speaking, you mentioned it. For a lawyer, how important is public speaking? Second part of the question, could I be a good lawyer and not a public speaker?
Well, as you know, there are as many different kinds of lawyers as there are subjects to have disputes about. And so there are lots of attorneys who don't ever have to get up and speak in front of anybody. And there are lawyers who only want to get up and speak in front of everybody. So no, it's not absolutely mandatory. It's really, especially for lawyers in the litigation field who are going to actually go to court. That's obviously the ones for whom it's the most important. But also it can be important just for speaking to groups of creditors if you're a bankruptcy attorney, or groups of family members if you're in probate law. There are times when you have to talk to people, but I don't think it's an intense public speaking experience for everyone.
I want to go and talk to you a little bit about your classroom experience because, when I went to law school, one of the first classes that I had to take was something called contracts law. And you taught contracts law, so you get a lot of first-year law students. Talk about what you see, when you're there as the professor. Do you see that there are some that are going to be great, and then there are some that are like, get myself into?
Well, it's really hard to tell, but I'll add to that not only have I taught contracts, which is a first-year class for a long time, but for about 15 years, I also taught remedies class, which in our law school is mandatory in the year of graduation. So I always got to see the difference between people when they walked in the door and knew nothing, and to the way they had changed when they were about to go out and they'd had some experience clerking for a judge or working in a law firm, and they were getting ready to go out, take the bar exam, and become attorneys. And there's an amazing transformation that takes place. With respect to your actual question, you know, I long ago figured out that it was impossible to tell from the way people behaved in class who was really going to be great and who just liked to make a lot of noise. And sometimes you'll get people who don't say a word, and when they do speak, you can barely pry anything out of them, and they sit down and take the exams and they know the law cold. So there's no rule.
To be a good lawyer, do you have to know the law cold, or could you get by not knowing it too well, but speaking well or writing well?
Well, there's a difference between knowing it and understanding it, because what I think a lot of people don't realize about the attorney business is that at some point somebody's got to do a lot of research. And so although a lot of people start law school thinking it's about arguing, they quickly find out it's about reading and writing. You may not know the law cold going into a particular case, but because of your reading and writing and researching skills, you will know the law cold when important things happen in the case. That is, if you're a good lawyer. And that's really what's important, is the ability to understand, ability to explain it when you have understood it, and the ability to carry that across and make your point and convince a judge or a jury, if it comes to that, that your client's position has merit.
I can't let you off the hook. We're talking about law school. We're talking about you being a professor. I can't let you off the hook without asking you about that little 3-day test that's probably about 7 hours each in California called the bar exam. Any advice or anything you'd like to tell our audience about the bar exam?
Well, I guess the main thing is, if you know anybody who is taking the bar exam, stay as far away from them as you possibly can, because they're going through an experience that they just can't relate to you, how awful it is. It's a tremendous amount of information that you have to know. It takes 3 days to take the exam. People typically study for a good 2 months solid leading up to it. It's an absolute nightmare. People tend to get pretty neurotic and edgy, and so that's the main thing, is if you know somebody who's doing it, steer as clear of them until it's over.
Do you think that people who have never gone through taking the bar exam really understand what the bar exam is and how hard it is?
Probably not. Probably not. It is a seriously difficult exam.
So now, we've talked a little bit about the law school that you taught at, and do you still teach there?
Yes, I do.
What classes are you teaching now?
Well, so now I recently, about 3 or 4 years ago, left my full-time professor post at the law school and went back into private practice with the law firm of Wagner and Jones. And so now I'm on the adjunct faculty, part-time evening classes, and I teach contract law every Wednesday night at the law school. Yeah.
You mentioned the law firm you're working at now, and I'm glad you did, because let's talk a little bit about what you're doing now, because off camera we were talking about some pretty cool stuff that you're involved in. So talk a little bit about what's going on right now in your world in the area of law.
Well, our firm, Wagner and Jones, is a plaintiff's law firm, and in particular, we handle personal injury cases, of course, but we also handle a lot of cases where we represent employees who have disputes with their employers. And we were talking about, a big issue in that area of law right now is the problem of employers requiring employees to sign arbitration agreements. Mm-hmm. And typically they do that when you first get hired, when they give you the employee manual and you have to fill out all your insurance papers or whatever they have you fill out. Typically somewhere in there, there's a little agreement that says, I agree that if I have any dispute over my employment, that will go to arbitration, which means that it won't go to court. It'll go to be decided by a private arbitrator who will act instead of a court.
Let's talk about the arbitration process, because a lot of people who have never been through arbitration don't really know what it's about. What happens in arbitration? And if it's not a judge that's actually sitting there listening to the argument, who is?
Okay, well, arbitration is part of this bigger topic that is referred to as alternative dispute resolution. And it's a wonderful thing in general. that there are ways that are less expensive, faster, more informal for people to have disputes resolved without having to go through the full-blown lawsuit. And so there are professional organizations that have trained arbitrators. They're almost all attorneys. Some of the arbitrators are retired judges who are no longer working as judges, and basically it's a private court. It's a private court system, and so the employer, if it's an employment situation, normally pays the fee. There's a fee that they charge, and your case is heard and just decided by the arbitrator. There's no judge, there's no jury. Everything takes place in a much less formal setting. So there are definitely advantages to it, but in the case of employees, there can be severe disadvantages to the employee as well.
How about if someone doesn't agree with the arbitrator? Is there something they can do to like appeal in a court? You can appeal a decision, and you've seen TV enough and you've been involved enough where the prosecution, when they win a case, the defense says, well, we're going to appeal. So talk about the appellate process in arbitration, if there is one.
Well, that's a great question. And of course, the answer is that there is no appellate process in arbitration. And so if you have a strong arbitration program, in fact, that is one of the complaints against compelling employees to submit to arbitration, is that the employer is a repeat customer. And even though good arbitrators do not have bias, there are social studies that have been done that shows that the more frequently that a party goes to arbitration, the more frequently they win, especially if they're the ones paying the fee. And I don't know really what the source of that is, but that's just a statistical fact. Once that's over, there's no right of appeal in arbitration like there is in a courtroom. And so that arbitrator's decision, that's right. And if you try to take it to court, you'll be thrown out of court. The other party will make a motion and the judge will throw the case out because the arbitration is final.
How about a contract or a document that says that if I don't like the arbitration, I get a re-arbitration or something like that? Have you seen something like that?
Oh, you can do that. In fact, one of the most important points about arbitration is the reason that you can be put into arbitration is because you have signed a contract agreeing to arbitration. Otherwise, nobody has any right to make you go to arbitration. It's the fact that you signed an agreement saying, in case there is a problem with my employment or a problem with consumer goods I purchased, as the case may be, I agree to go to arbitration. And in that agreement, you can put whatever provisions that you want. But the reality of it is that it's that the more powerful party that is normally making the weaker party sign the arbitration agreement, and they're not going to agree to have rights of appeal. If you don't like how the arbitration came out, you can pick another arbitrator. They're not going to say that.
How about in the case of like other things, other than employment? There was something about a company with cell phones that had an arbitration clause. Talk a little bit about that.
Sure. In fact, this is a very significant decision by the United States Supreme Court in a recent case involving some consumers who purchased cell phones from one of the major carriers. And the carrier had advertised that if you signed up for a certain plan, you would get a free cell phone. So thousands of people signed up for the free plan so they could get their free cell phone. When they got the cell phone, they also got a bill from the carrier saying that they had to pay sales tax. Well, this was a really good example of a very, very minor harm, very, very minor amount of damages that each person suffered because they said, well, I was entitled to this thing for free and you misrepresented it and I had to pay $15 or $20 or $25 sales tax, and so that's what your suit is over. Well, if you've ever been to a lawyer, you know that you really can't even park for $15 or $25. So one individual with that claim is really not going to file a lawsuit. So what these people did was they got together, they spoke to a lawyer, and they filed a class action suit on behalf of everybody who had purchased the cell phone. And instead of asking for $15 or $20 or $25 for one or two people, they asked for $15 or $20 or $25 million for all of the people collectively who didn't get a totally free cell phone. It turned out, though, that in the service agreement, In the fine print, it said, if you have any dispute over this, you have to agree to go to arbitration, and you may not have class action arbitration. You can only arbitrate one person at a time. Well, this, of course, effectively made it not worth the money. You have to go up now against one of the biggest corporations in the world, and all of the attorneys that they can bring to the table. You have to try to get documents and records and take depositions of company executives and all kinds of things that takes a lot of money, and an individual consumer typically doesn't have the time, interest, or resources to take on something like that. So essentially the translation of that clause is, if there's anything wrong with this agreement, you have no rights.
And so let's say that someone has a situation like that where it is a class action or something. Then they come to attorneys like you or law firms like yours, and then what do you do with the facts once you get it?
Well, what we're looking for when we evaluate a case like that is, does the person who has a problem have the same problem that lots of other people have? That's really what a class action is about. It's just like the people with the cell phone. They all signed the same cell phone agreement. They all signed up for exactly the same plan. The same promise was made to all of them. They all have the same problem. So we can collectively put them all together and efficiently answer the questions about this, who's right and who's wrong, for all of them together. The same thing would be true in an employment setting where we would have people, for example, who were entitled to be paid overtime if they worked over 8 hours in a day, and it turned out that their employer didn't pay anybody overtime, and we have hundreds or maybe thousands of people with the same problem. So that if we can present that case to the court, showing that everyone has the same problem and we can make the same inquiry, the same group of witnesses, the same documents, rather than litigating that case 800 times or 1,000 times, we can litigate it once on behalf of all of them, then we can get a court to certify that the case may go forward as a class action suit, and that's how we would proceed.
Going back to the arbitration clause, in the clause, does it say who has jurisdiction? I mean, let's say that the company that I signed the arbitration agreement with is in Delaware or Texas. In that arbitration clause, does it say they have to come here to California, or does it say I have to go to Texas or Delaware?
It can. It can say anything that the author of the agreement wants to make it say, and if they can get you to sign it, it can stick. And so that's one of the great complaints about forced arbitration, is that oftentimes the employer, or if it's consumer goods, the manufacturer, will put in very, very harsh provisions that may say, they may limit your rights to obtain evidence. They may require that regardless of where the dispute arises, it's got to be heard in a certain state. A very famous one involved the Neiman Marcus company, which had a provision that said, well, regardless of which store you work for, if you have a complaint with the company, you can go to arbitration in the locale where your store is, but the arbitrator has to be an attorney from Texas.
So basically they're saying you bring suit wherever you want, but the person that's going to hear it is going to be from where we want him to be or her to be.
That's right. And in fact, the Neiman Marcus agreement went further and said, if during the course of the arbitration we don't like the way the proceedings are going, we have the right to name 2 additional arbitrators of our own who will now join this other arbitrator and form a panel, and they'll continue on and make the decision. So it's a very, very harsh one-sided agreement, and one of the reasons why, in fact, legislation has been proposed in Congress to change the way the arbitration law is applied in the United States.
This may be a tough question for you to answer, but is this Congress more for arbitration agreements or against?
Well, that's a really great question, and this is, some people may have figured out, this is a highly political issue. Depending on where you stack up politically, you may have a different view of this. And the Senate, of course, is more likely than the House to pass legislation that would change the way arbitration provisions are applied. The proposed legislation would affect only cases involving consumer purchases, employment, some antitrust cases, and civil rights cases. And the legislation would simply say that an arbitration agreement cannot be enforced if it is signed before the dispute took place. That's all that it would do. The House of Representatives, that they're very divided on that. I don't know what the prospects are for the House passing it. It has a lot of support in the Senate right now.
So our audience members should follow this one because this one could get interesting.
It can get interesting. It can affect your rights as a consumer. It can certainly affect your rights as an employee. And these days, almost every employee who signs on with a company gets presented with an arbitration clause, and a lot of people who are already employed have been given arbitration agreements or will be given them and told that if you want to continue working here, you're going to need to sign the arbitration agreement.
Interesting. Let's shift gears a little bit and talk about something else. I'm building a fence, so I want to bring the fence hypothetical. I'm building a fence, and the neighbor tells me, yeah, a fence would be nice because our fence is old. If I go and build that fence, can I send him the bill?
You can send him the bill, but it would be entirely up to him if he wanted to pay it or not. You certainly, I know you're asking me in a roundabout way if there's a contract between these two property owners, and the answer is no.
Can there be actions or comments by one person that would lead to a contract in that situation? So let's go back to the fence building hypothetical. I tell my neighbor I'm going to build a fence. My neighbor says, yeah, you go ahead and do that and I'll help you. Now if I go to get the supplies and build the fence, what do you say now?
Well, your case is getting better. Your case is getting better because now he said, I'll help you. And so now what we would want to know under the laws of contracts is whether a reasonable person would have thought when he said, I'll help you, that he meant, I'll help you by paying part of the cost. I think you're still on kind of shaky ground because I think most people would say, well, he's going to come help me build it. But I don't think he said he was going to help me pay for it just yet.
So what would someone like that, I mean, the reason I ask you is because stuff like this happens, and you know from your experience, day in and day out, conversations like this happens in neighborhoods all over the place, and not just with fences, with all kinds of other goods. So let's say that I believe that he wanted to help pay for this fence. Would I file a small claims suit, or what would happen next?
Well, yeah, small claims. I think the limit on small claims is a maximum of something like $7,500. It may have changed. I'm a lawyer, so I'm not allowed in small claims court. Yeah, you could do that. It's a very informal thing. I will tell you that a big tree came crashing down in my yard and destroyed the fence. And so my neighbor and I had to come to exactly the same agreement that you're discussing. And it's really not too tricky. My neighbor said, will you pay for half? And I said, yes, I will. And being pretty good neighbors, that's all it took, and nobody had to go to court.
But in that case, would you want to get a written agreement, or do you think that the verbal agreement is okay?
Well, that's a great question because in law school, we study certain agreements are required to be in writing and certain agreements are not required to be in writing. But then I say, well, you know, if you're a lawyer, all agreements are required to be in writing. As a lawyer, you're not going to counsel anybody to get a verbal agreement. But as a practical matter, two neighbors talking about a fence are not going to put it in writing. And so that's a matter of a little bit common sense. You know, do you trust your neighbor and how well do you communicate? But obviously you would want to be really clear about what I expect you to do and what you agree to do. So that's really the answer, is communication.
And then around the same idea, right now there's a website people go to and they buy cars and they sell cars and other goods as well. In a situation like that, if I list my good on the website and someone comes and looks at it, do we need a contract? I mean, can he give me the cash and I give him the keys and we have a contract, or would you rather it be in writing?
Well, the thing about putting contracts in writing, this is a real simple rule of thumb really, is if it's something that the other person has to do in the future, you want to put it in writing. But if you and I are just going to stand face to face and you're going to give me the money and I'm going to give you the whatever it is I'm selling, we don't really need to put that in writing to carry that out on the spot.
Let's go back, and we're running out of time this week on the program, but let's go back and talk about a little more about you. Where do you see yourself in 10 years? I mean, do you see yourself being a lawyer for years and years to come, or do you think you want to do something else?
Oh, I don't know. I have a lot of interests, but I'm kind of having a good time at Wagner and Jones right now. It's a great group of people. I really enjoyed working with them. It's a small, congenial office, and we work with other groups of lawyers that we're affiliated with throughout the state, and it's very interesting work. So right now I'm just kind of going with the flow and seeing how it goes.
You know, on that topic, I want to ask you a question. In the courtroom, two lawyers can pretend, or it may be true, that they hate each other's guts and they're going after each other. But is it common for them to afterwards go and hang out, or, you know, go to a place where and talk civilly?
Well, you know, it's just like all the people you know at work. Some of them you really get along with, and some of them you don't. And it's really, it cuts both ways. I had a trial in Fresno a few years ago where the opposing attorney acted, it was 3.5 weeks long, and he acted like he was just outraged, furiously angry throughout the entire thing. He really came across as a terribly unpleasant guy, but that was, you know, that was his game plan. He wanted the jury to think that he was just offended and outraged. And I remember in the closing argument, you know, I had run into him in a local restaurant. We had chatted on the phone. He was okay, you know, he was just acting. And I remember in the closing argument, I got up and told the jury that, you know, he seems like he's mad all the time, but he's really a pretty nice guy, you know. So,
speaking of nice guy, how can people get a hold of you, or how can they contact you and ask you questions or anything you've talked about today?
oh, they can reach me at the Wagner and Jones law firm in Fresno.
Thanks, Larry, for coming on the program.
It's been my pleasure.
That's all for this edition of San Joaquin Spotlight. Our guest this week has been Professor Artenian, also a local lawyer in town. Thank you for tuning. Thank you for listening to us. And thank you to the volunteer crew that made this and every production possible. See you next week for a new show.